Carlee Russell, and she faked her own kidnapping there in Hoover, Alabama. She called 911 to report a toddler missing on the highway. But she was in court last week and she pled not guilty. But she was found guilty of false kidnapping and ordered to pay about $18,000 in restitution and spend a year in jail. So, Dimitri, what are your thoughts on this? Because I know we talked about this. This is our first thing we ever talked about.
Yeah, she was found guilty. What a shock. Who saw that coming? Well, I mean, her own lawyer held a press conference and admitted that she did it. So I don't know. Look, this case is really weird because you have these two kind of countervailing interests, right? Because obviously, we as society have an interest in people not reporting fake crimes, not making up crimes, not using government resources and the police to further whatever objective they may have that isn't for the purpose of truthfully reporting a crime. And that's important, right? Because if the government, and by the government, I mean police and all other law enforcement agencies, aren't investigating real crime, then that's a problem because they're investigating made-up crime, right?
Mm-hmm.
On the other hand, when you have a case like this, it's easy to come to the conclusion that we're all coming to. It's easy for the judge to come to the conclusion that the judge had come to in this case, right? The problem with something like this is the collateral damage, right? Because you have a case like this, and what you don't want is for the next victim of a crime to be afraid that if he or she may not have all their T's crossed and I's dotted, that at some point it may look like a crime is made up and there may be consequences. Now, look, as somebody who does this for a living, I can tell you that there's a whole lot of gray in the criminal law. People almost never completely make stuff up out of the blue like she did here. That almost never happens. Sometimes, but almost never.
Mm-hmm.
And so it's not something we really have to worry about. But it does create that possible issue, right? We don't want victims of crimes to hesitate at all in reporting crimes, at all, right? We want them to go to the police and say what they feel and then let the police do their work. So it's I guess, justice served that she was convicted. I get that, not disputing that, but we have to be careful before we use this as a vehicle to condemn how the criminal justice system works, you know?
Right. I mean, some people think she got off lightly. Some people think she should have gotten, more of a sentence. But how does this work? Because she left court, like she didn't go directly to jail. She left. And then now she's appealing this conviction, this ruling. So what happens from that point, Dimitri?
So the way these things work is oftentimes upon a conviction, the judge can either remand the defendant right away, which means send the defendant away to the term of incarceration, or the judge can defer the sentencing, right? Set a sentencing date. In federal court, for example, that's almost always what happens, right? A judge will, obviously there'll be a judgment of conviction, either by a jury or by a judge, and the sentencing date will be thereafter held maybe a couple of months, right? In state court, you have options. People sometimes go right away. Sometimes there are deferring sentencing dates. Now, in cases of appeal, things get a little tricky, right? Because when folks appeal convictions, you run the risk of incarcerating an innocent person, right? Because you have arguments technically that may have merit on appeal. And so what lawyers often do is they ask for the judge to stay the sentence pending the appeal. And then you have another problem where an appeal could last several months and many months, and you're kind of lingering with this case. So that's kind of the issue here, right? The judge will have to decide whether or not the sentence will be stayed pending appeal or whether he'll put her in pending appeal. And then if the case is, the verdict is reversed at some point, she'll obviously be released.
Okay. Well, thanks for explaining that because I was a little confused that she was leaving court, with being found guilty. So
Very common.
that's good to know. I mean, I'm glad that I don't know these things because it means
Yeah,
I've never experienced them.
exactly right. That's what I tell when I have clients come into my office and they say, "Oh, this is my first time. I don't even know what's happening," and I go,
Yeah,
"That's a good thing. That's not a bad thing. You
right,
don't,
exactly.
you don't want
Lu-
to know what's happening."
Luna has a really good question.
Yeah,
She said, "We don't know what she was going through. Please, Jay, ask him whether her mental state was examinated and whether that means something."
that's a great question. That's a
Hmm.
terrific question. So look, in order for somebody to commit a crime legally, and what I mean by that is, in order for them to be convicted of a crime, the prosecutor has to prove mens rea, mental state, right? And that can be either intent or knowledge or recklessness or negligence in different states, phrase it in different ways. And, you have to prove, generally speaking, in the criminal law, in order to convict somebody, that something was in their head, right? And you take that mental state and you combine it with what they call the actus reus, the physical act, right? To cause a certain event, right? Which is the result, that is the crime. So when that happens, one defense that a defense lawyer may explore is incapacity, right? Or some places call it insanity, right? And you explore whether or not that mental state element is satisfied. Okay. And that's what happened here. I presume that this was something explored by the defense lawyer and used as a defense if it could have been. Now, in order for insanity to be a defense, you have to meet very strict criteria, right? Um, and there are different insanity tests depending where you are in the country. Generally, it has to do with something like the defendant lacked the capacity to understand the consequences of his or her actions, right? It can be that the person was upset or depressed or anxious and therefore committed a crime. That's not a defense, right? That may be a mitigating factor, as they call it, for sentencing, for example, but that's not a legal defense. And so that is the way mental health issues work when it comes to defending a criminal case.
I'm glad you mentioned depression and, along those terms of mental, illnesses or mental things that people
All,
can be suffering from. And it's
all
interesting to know
very,
that's not one of them. I mean,
all very real issues, right? That
right.
people go through. I mean, we're
But
very,
it doesn't fit
very.
under the law of insanity, right?
I don't want to say it doesn't fit. It may, depending on the state that you're in and the
The
the,
circumstances.
the circumstances, right? You don't want to say that because depression is a loud word that means so many different things, and
Hmm.
it really you should
And you don't want
defer
to downplay anybody's, mental health conditions.
and you also don't want to put yourself in the shoes of a clinician who really can connect these dots the right way. So what you can do in court is come in and say my client was upset about something and therefore committed a crime. That's not a defense, right?
Hmm.
That's what I mean, because I think there was some discussion in this case about why she may have done this. This is all from the press. None of this is verified
Yeah.
as far as I knew. And if those issues were in fact accurate, which again nobody knows anything, then it's not necessarily true that that could have worked in her favor here.
Hmm. Hmm. And I agree with Selena, who says, I believe her intention was attention. I don't know why, but obviously maybe a boyfriend or something like that. But Kendi has an interesting question. Would there be a tox screen? When she came home that morning and they called 911 and said she's home, she's breathing, and she went to the hospital, is that something she would have to have consented to? Or could they have done that without her consent?
It depends. It's a weird question. A tox screen.
Like a
Um,
like a drug test.
when you say consent, right? What do you mean by that? In
Like when
order,
she was taken to the hospital, did they say, "Okay, we want to draw blood to see if you have anything, any drugs or anything in your system. If you say you were abducted, I mean, we want to see if this person drugged you.
Yeah. If there was some indication that the police, the government, wanted to get her to get a tox screen, to then use that tox screen in a criminal case against her, you have a whole set of constitutional rules about consent and Fourth Amendment and searches and seizures, right? What the government can pull out of your body to use against you in court, right? There are whole constitutional doctrines about whether or not those things are in effect confessions and things of that nature. So that gets real delicate. If she consented, that makes the analysis a bit easier, but it's still a complex analysis. Now, that's different than if she's suffering and the doctor in a hospital had to do something for medical reasons. That's a different story. But if you're going to pull something out of her body to use against her in a criminal case, that's a different. There's a whole body of Supreme Court case law and the courts that are under the circuits, right, that are instructive as to this. It's a real complex issue, as you can imagine it would be, right?
Yeah, I mean, you have a girl who says that she was abducted and possibly harmed, and then you're talking about wanting to do a blood screen on her. It's
right.
Slippery slope there.
There was a famous Supreme Court case where there was, well, I'm going to just simplify it, right? There was a boy that was accused of dealing in drugs. And when the police came to his house to search, he swallowed them all. And they wanted to say, okay, we're going to go to the hospital and pull him out of you. And he said, no, you can't do that. And they did. And he was convicted. It went to the Supreme Court, so on and so forth.
Wow.
So there's a whole body of case law about what the police can take out of your body to use against you in a criminal case. And thank God for that. No.
Did they use the reason that he could have died from having ingested all the drugs? Is that why they were able to?
But that's different, right? So if they take it out of his body for a purpose not to use against him in court, then there are legal exceptions to the Fourth Amendment, let's say, that allow it to possibly come in. And as a general matter, by the way, judges very rarely exclude evidence, right? The exclusionary rule, which is a big deal in criminal law and constitutional law, the fruits of the poisonous tree doctrine, which is a big deal in criminal law and constitutional law. Those are very rarely relied upon to exclude evidence, to suppress evidence, as they say in criminal cases.
John Gahn says, give her 6 months in prison and let's move on.
Well, yeah, maybe. We will see. Right?
What do you think she'll end up? I mean, if they said she can face up to a year, do you think that she'll do that time?
It depends on the sentencing rules in Alabama. I'm a lawyer in New York. Typically, they have some time that you must serve prior to being eligible for some early release in most of these places.
Seems like it, yeah. I mean, especially for misdemeanors, right?
Right.
Hi, Potato. She's listening on her way home. Hello, Miss Potato. All right, are we ready to put Carlee Russell aside for now?